Please call the roll.
Here.
Excuse me, get that on the record. Purcell for
Here.
Cox. Pratt. Castanis.
Here.
Collin. Yee.
Here.
Toby Johnson. Dickinson.
Here.
Panay.
Here.
We have a quorum.
All right. This continued item from the April 7th meeting of the Sacramento Metropolitan Cable Commission is being videotaped in its entirety and will be cable cast without interruption on Metro Cable 14, the government affairs channel of the Sacramento cable system. Today's item is being cable cast live and will be repeated Saturday at 2 p.m. A VHS copy is also available for checkout from any library branch of the city and the county of Sacramento. Members of the audience wishing to address the Commission should fill out a speaker identification form located at the entrance on the table and give it to the Secretary. Please speak into the microphone when addressing the Commission and state your name for the record. Okay.
Mr. Chairman, members, good morning and happy tax day. When we continued this item at your last meeting, the concerns we had were that we were able to present to you in concept, the unconditional guarantee that had been offered by Sacramento Cable and Scripps Howard Broadcasting, as well as the corporate parent EW Scripps. But at that time, we didn't have the detail. In meeting this week and in intensive activities with Penny Cost and Kevin Jones, Penny being the Scripps Howard Sac Cable attorney, Kevin Jones being the Sac Cable corporate controller, they were able to provide us with the actual documents. As explained to me by counsel and staff, they meet the two criteria that were important for me. One is that there is the equivalent of joint and several corporate liability for the obligations of your franchise, and that guarantee is readily accessible to us if should there ever be a need to enforce a material breach of the franchise. With that and upon advice of counsel, I recommend that you follow the recommendations of counsel, and I also ask her to describe in a bit more detail the elements of the guarantee.
Okay. Why don't we have counsel, Ms. Steiner?
Good morning. What you have before you in the guarantee is EW Scripps, which is the parent company of Scripps Howard Broadcasting, guaranteeing the obligations and duties of Scripps Howard Broadcasting under the franchise. Scripps Howard Broadcasting is a franchisee, and they are jointly and severally liable for all of the activities and requirements of the franchise. EW Scripps, as their parent corporation, has agreed to guarantee all of the obligations and duties of Scripps Broadcasting. They've also agreed, as part of that guarantee, that the Commission does not have to exhaust any of its remedies against the broadcasting company before it goes against EW Scripps. They have, in addition, agreed that the guarantee will stay in place, notwithstanding changes to the franchise that are agreed to by Scripps Broadcasting and the cable franchisees and the Commission, and notwithstanding regulatory changes that you may enact at a later date. The guarantee is basically unconditional. It's irrevocable. It'll last through the term of the franchise. And if you have any questions about that, there is a memo in your packet that attempts to outline what a guarantee is and the rights and remedies of the Commission with respect to that guarantee, and basically goes into a little bit more detail than I have this morning. Also in your packet, you have a certificate of acceptance for Scripps Howard Broadcasting. This document is identical to the one that was executed in 1988. When the merger occurs and Scripps Howard Broadcasting is merged with this new corporation, and the surviving corporation out of that will be called, as I understand it, Scripps Howard Broadcasting. So to look at it from a name change, you wouldn't know the difference. That new corporation, that merger corporation, will re-execute the certificate of acceptance so that there is absolutely no question that they are bound by the terms and conditions of the franchise. We did send the packet that you have in front of you to Lee Elam County Council. I spoke to him this morning. He has no problems whatsoever with anything that's in there and concurs in our recommendation. And you have also in the packet a resolution for your consideration, which lays out the terms and conditions of your approval of your finding that the presumption of a change of control has been rebutted and approving the merger transaction.
Okay. Any questions from members of the commission? Mr. Castanis.
Harriet, I have a question regarding the graph that you have post-merger. It's not numbered. Would you find that a moment? And I guess there's a lot of number 2 pages there.
Sorry.
It's labeled post-merger at the top.
It looks like this.
Assuming then that Sacramento Cable were to get tired of serving this community and wanted to pull stakes and leave town, what would our remedy be then based upon this post-merger if we accept your recommendation here today? What would happen? What would we do? What remedies would we have to secure restitution for such a
You would have remedies against Scripps Howard Cable Company for not complying with the franchise. You would have all of those same remedies against Scripps Howard Broadcasting because they are one of the named franchisees. And you would have all of those same remedies against E.W. Scripps Company as the guarantor of the obligations of Scripps Howard Broadcasting.
So we'd be totally covered with all of those 3 entities then?
That's right. That's right.
And let me verify this. If the system were to be transferred or sold, your ordinance provisions on that would apply to review that. But our understanding is that, my understanding is that the guarantee would travel with such a transaction, so that a sale to XYZ Corporation, XYZ Cable Company, would mean absorbing at their level the corporate guarantee as well, correct?
Yeah. Well, I think that that's true, but clearly, if there is an actual sale of the system with the guarantee in place, that's one of the things that that we would be discussing as part of that transfer, because you would have, if there was an actual sale of the corporation, of the franchise to an unrelated party, you have the absolute right to cancel the franchise at that point and to renegotiate the terms.
When we started the franchise, I remember that joint and severally liability was a very important issue, and we went through a great deal of turmoil in that regard. We still have that joint and several liability obligation with this merger.
Absolutely.
Yeah. Okay. Any other questions by commissioners?
Let's add one point. We actually have it at a higher level. As of today, the joint and several liability ends at Scripps Howard Broadcasting. With this guarantee, the joint and several liability through the guarantee goes to E.W. Scripps. So we've ratcheted up one.
Good.
Okay. Any other questions from commissioners? Okay. We have.
I'm sorry, Judge.
Yes,
Let me just ask
Mr.
one,
Dickinson.
just in a slightly different approach here, and I haven't had a chance to look at this through my own inadvertence, I'll say. Assuming, and staying with the chart just for purposes of ease, it would take what you've denoted as ultimately old, well, we don't have old broadcasting company, I guess, anymore after this. Is that right?
That's right.
I mean, even though you show them on post-merger, I mean,
Well,
it's
their
just,
share, as I understand the transaction, the current 13.9% shareholders of the broadcasting company are exchanging their shares in broadcasting for shares of E.W. Scripps. So those shareholders will become shareholders of E.W. Scripps.
E.W. Scripps, right.
Along with all the other shareholders of E.W.
Right.
Scripps.
the only practical means of avoiding fulfilling its obligations, if not legal liability, then with respect to all the elements in the chain from Sacramento Cable up through E.W. Scripps would be if they all found themselves one day without any assets.
That's correct. I mean, they'd all have to be bankrupt,
Yeah.
I mean, clearly bankrupt and without any assets.
Okay, thanks.
I mean, maybe I should clarify. To the extent that they do something and they have a legal defense to it, I mean, they would, they still retain all of the defenses. that they might have in any legal action.
Sure, but absent
But
that,
absent that, yeah, all of those companies would have to be without assets.
and the ability to comply, to compel compliance with the terms and conditions of the franchise agreement here extends unconditionally to E.W. Scripps, if I understand this correctly.
Right, as a guarantor of the obligations of the broadcasting company.
Okay, thanks.
Okay, any other questions from members of the commission? All right, we have one person, the legal counsel for Sacramento Cable, Penny Costa. Would you like to speak, Ms. Costa? Why don't you come forward?
I'd be glad to answer them. Otherwise, I think I'm happy to rest with the comments and recommendations of your executive director and counsel.
Okay.
Oh, let me just ask
Yes.
one question for any and all of you, or all of you. Has commission staff seen the original documents that would say? I understood you wrote a memo detailing, Penny, what the terms of the transfer were and the like.
The memo that I've written is part of your package. There is no merger agreement at this point because the discussions have not proceeded to a point where there could be a draft merger document for you to review. But the memorandum and letter, the certificate, the guarantee, those are all attached to your packet of materials. The certificate and guarantee are in the order that they will be in when executed at the time of the merger, if that in fact occurs.
And
They
so-
are not. The guarantee says draft on it. That is the final version because your council has approved it.
And that has to be adopted by the parties in the context of the merger as well.
That's a condition of the merger closing, that those documents be executed.
Right. And then we're putting in our resolution that should any of this not be effectuated, then our action is essentially null.
Your resolution provides that, first off, at least 15 days prior to the close of the merger transaction, they have to give us the actual merger documents so that your legal counsel can review them and make sure that they're consistent with Ms. Costa's memorandum as to the actual structure of the transaction. They have to fax to us from the closing executed copies of the guarantee and the certificate of acceptance, and then the actual copies have to be received by the commission within 5 days of the close.
Right. So we can
If
expect
any of that doesn't happen, your approval is null and void.
So we can expect to hear back from you that you've received all these documents and they're in proper order or not.
Right. And Ms. Costa may be able to speak to it. I don't anticipate that this will close. I think it will close at least 90 days from now. But the other thing your resolution says is if this transaction does not close by the end of 1994, then your approval is null and void, and they have to start the process again.
All right, thanks.
Okay, any other questions, members? Yes, Ms. Collins? Yes. Okay, Mr. Purcell.
Excuse me, just for curiosity, what are the assets of the company at the top of the chain?
E.W. Scripps assets are nearly $1.7 billion. It's 1.67 something billion.
Okay. Anything else?
As part of the transaction, we will get their financials.
Okay, Mr. Costanis.
Penny, is there any chance that this will not happen, or?
Well, at this point in time, the parties have agreed upon what we all consider, I think, to be the major term, which is the exchange price of the stock. Of course, the rest of the details need to be worked out, and those are the things that make up the parts of the merger agreement. But we're very hopeful that it will go forward, and all of the parties are working forward on that basis. If something were to happen and it became apparent that the merger would not occur, we would, of course, notify you.
Okay. Any other questions from members of the commission? Okay, seeing none. Any members of the public would like to testify on this item, this continued item from the April 7th meeting? Okay, seeing no one coming forward. We have a resolution in front of us, members. Is there a motion on that resolution?
I will move staff recommendation adopting the resolution.
Okay, Mr. Costanis has moved. Mr. Yee has seconded. Is there any question on the motion on the table? All right. Would the secretary please call the roll?
Castanis?
Aye.
Collin?
Yes.
Yee?
Yes.
Dickinson?
Aye.
Purcell?
Aye.
Panay?
Aye.
Motion carries.
Okay, the motion carries. And that motion included closing the hearing as well. Okay. Do we have to call for any members of the public who would like to testify at this time?
Since this is a special meeting under the new rules of the Brown Act, public comment is limited to the items that are on the agenda.
I see. Okay. All right. Well, if there are no, is there any further business? Mr. Espasto.
Just quick comments at your next meeting on the first Thursday in May. The preliminary agenda has report backs on affirmative action, status of the implementation of rate regulation. Diane and I spent the last 3 days with the FCC, and we're blurry-eyed and beginning to sort things out. Report back on your policy guidance on the grand jury, status report on legislation, and a request by Sacramento Cable to make some amendments to the customer service regs. It's your preliminary agenda.
How did we leave the affirmative action?
Left the affirmative action where you referred the podium presentation from Sacramento Cable last month to the city's affirmative action officer to include that as well as the written material that was provided, which we've now copied and will be distributed to you, for him to report back to you at the next meeting. He will be doing an analysis of the documentation and the presentation.
I see. Well, members, as you have probably seen in the press, there have been other lawsuits filed against this operator. I think it's timely that we were looking at their affirmative action goals, but I think we should consider at the next meeting possibly looking a little closer at this company's operations. It's up to the membership, obviously. We can do what we want within the bounds of our rules and regulations, but I think we should look at it at least. I think it behooves us as the stewards of the public trust here. And with a considerable amount of legal action, I think we should take a look. So you might be considering that before our next meeting, and we can discuss it then. Okay? All right.
Question.
Yes, Mr. Castanis.
Rich, regarding the budget, when will we be discussing that? Is that going to be at our June meeting?
Historically, I try and get the budget to you in the agenda packet for May, and then we discuss it in June. Given other workload, I don't think I'm going to have it for you with the agenda, but shortly thereafter, I will distribute the budget for discussion in June, so you will have at least 3 weeks to look at it. Okay.
Now, the issue of the was it $1.2 million reserve that we'd set aside? Have we decided all of that?
1.7.
1.7. Has that been determined, or is that still open for discussion? Where are we with that?
That was decided. Your decision was to hold that in reserve, pending future decisions for essentially until the nationwide status of franchise fees is determined in January of '96, as it relates to us.
Right. So, okay. So we'll not be touching that in the discussion of the budget then,
barring any other decision by you to change that policy.
Yeah. Is that? I think that's correct. That's what we talked about.
Mm-hmm.
Yeah.
Actually, two jurisdictions.
Two
Folsom
jurisdictions.
And Galt asked
both Folsom and Galt. Yeah.
Okay.
I mean,
yeah.
I suppose if you want to entertain some other, our parents have spoken, but if you want to...
No, I just had to review it. I'm afraid I forgot, like Roger, if you didn't read it, you didn't see it or whatever, but I just needed that review.
It didn't happen.
It didn't happen.
All right.
It
Mr.
is
Dickens.
indeed.
Mr. Dickens.
A thought just occurs to me, Terry, that your comment raised, although it's not particularly connected, is does it make sense to put on the agenda, at least for the next several months, a legislative report?
Yes, I have that on. I just mentioned that.
Okay,
I have
I'm sorry.
legislation scheduled for every month now.
Okay, good.
Okay.
Both federal
I missed you
and
saying.
state.
I missed you saying that. Okay, good.
Well, if there's no other business, so adjourned.